I got
somebody. Mr. Linton? You're muted.
Yes, ma'am.
Your matter was reset until December 29th, so your attorney can work out some details, okay?
Yes, Your Honor.
You're all set.
Thank you, Your Honor.
You're welcome. Let's see. Okay. On the record, in the matter of the people of the state of Michigan versus Andrea Harton, file number 18-00682, FY, counsel appearance.
Jeff Rodos on behalf of the people, Your Honor.
Okay, and Ms. Harton, my understanding is that you were denied a public defense counsel and you wanted to appeal. However, the people are moving to dismiss your case without prejudice as it's in the interest of justice, okay?
I'm sorry, Judge, my screen muted out and I did not hear that after the public defender. I'm sorry.
Okay, no problem. I was telling you that the prosecutor's office is moving to dismiss your case at this time without prejudice. So the motion to dismiss will be granted. That means the case will be dismissed today. They do, however, have the right to reissue the case against you, so long as they do so within the statutory time frame. Let's see here.
I don't know if she knows about that.
What is the reason for the, just put the interest of justice?
Yes, Your Honor.
Okay, this wasn't as part of a plea deal or anything.
No.
Okay,
No,
sounds
Your
good.
Honor.
Okay, and so this was a 2018 matter, correct? 2017. So yeah, they have the right to reissue as long as they do it within the statutory time frame. Okay?
Okay,
Your matter is dismissed today and you can get a copy of the dismissal sent to you in the mail, okay?
okay. Do I need to find out or speak to anyone in particular in regards to my bond and things like that? Do I just reach out to whoever I was bonded from?
Did you have a bondsman or did you post a cash bond?
I posted a large cash bond with Leo's bondsman downtown when I was arrested.
Okay. You would need to contact your bondsman and see if you have any recourse there. Typically, when you post a bond with the bondsman, you're paying them a fee
Okay.
to put up that bond amount. But that's up to the bondsman if you're eligible for any refund, okay?
Okay.
Okay, you're all set.
Okay, thank you so much.
You're welcome.
Bye-bye.
All right.
Judge, with regard to Mr. Palacio, I was originally assigned to represent him, but he's retained Toby White.
Leave.
Do we have a substitution?
We
So-
filed, oh, go ahead.
Well, so the clerk's office, they put it in, but they didn't enter it technically the right way, so it still shows Mr. Palmer is, but I'm about to go change it right
Well,
now.
they can't, the reason why they didn't put it in is because I didn't sign it.
Did they give it to you?
No, they just put it in the file.
That would be why it's still on.
Yeah, that would be why.
Yeah.
Well, I'm here. I'm here on other things anyway, but I'm here partly because of this issue. I noticed yesterday that the court had changed my name off of it.
Okay, I'm signing it now.
People are not keep the substitute.
Oh, you didn't receive a substitution?
No, we
either?
didn't. We had,
Okay.
at least, yeah, as of yesterday, when Mr. Palmer informed me
Oh,
that the Mr. White had been retained, we had not received a substitute from counsel either.
Yeah, the court looks like they received that back on the 14th, a couple days ago. Is Mr. White coming today?
Mr. Palacio, can you hear me?
Yes.
All right, you've retained attorney Toby White, is that right?
No, I'm in the process of getting Jamie White.
Oh, Jamie White.
Jamie White. Is Jamie, well, let's see here.
Jamie's not gonna be
Jamie?
here today.
Oh, you know why they didn't, let's see here. Jamie didn't sign this either.
Yeah, no, because I gotta make it down there this afternoon to sign the paperwork. I didn't sign the paperwork, so he's not, he just told you to tell
I
him
just see Feigelsen's
I'm in the process of
Feigelsen's
retaining him.
signature. Okay,
So,
sounds good.
Judge, for what it's worth, this case was assigned to Mr. Feigelson. Mr. Feigelson leaves for vacation today, I believe, or maybe tomorrow. But the point was, he wasn't gonna be here for the prelim for sure. And so then they reassigned it to me, and I think filed an amended appearance, as I understand it. But by the time the case reached my desk and filed an amended appearance, I think Mr. Feigelson had already negotiated or had already signed the substitution of counsel and had it entered. Now, if he hasn't actually officially retained Jamie White today, or as of yet, then I think probably technically my office is still on the hook for Mr. Palacio.
Okay, I don't see a signature from Jamie White on this substitution. I'm assuming Mr. Feigelson maybe signed and sent this just in case, since he wasn't going to be here. It's just sitting in the file, not sure how it got here. I had nobody's signature except for Mr. Feigelson's client has not signed, and neither has Mr. Jamie White, nor had I. Nonetheless, Mr. Palacio is scheduled for a probable cause conference today and has an exam next week. We'll continue until next week, and we'll treat it as a probable cause conference. I need all the paperwork signed before then, okay?
Yes, Your Honor.
Okay. And then we'll address your timeline next week, once we have your attorney present, okay?
Okay, thank you.
Mr. Palacio, I'm sorry, just didn't mean to interrupt. Mr. Palacio, my name is Rob Palmer. I'm from the Public Defender's Office. I can call you later today if you're available and kind of explain what's going on and what we need to do to move forward, if that works for you.
Okay, please and thank you. Do you have my phone number, sir?
I believe I do. Let me double check it. Is it the telephone number ending 0082?
Yes, sir.
All right. Yep, I have it. I will call you shortly.
All right, thank you.
Yes, sir.
Okay, you're all set for today, Mr. Palacio.
Yeah, thank you.
Thank you. You give Miss Donnelly a new date on hers?
No.
Is Mr. Myers here?
Yeah, he's out in the hallway.
You just want this set out because of the screening?
Yes.
Okay, we'll get you a new date. He's
So-
being screened
It's for 30th.
uh, January.
Okay.
Yeah, that'll take a while. I'm just.
And
He was
set it for another plea or?
We'll set it for another plea.
Okay.
Judges.
January
So it's all gonna
6th.
be handled here,
And-
but he's, like I said, he was
Just go
down
get
getting
numbers.
fingerprints.
January
and there
6th
were
at 9
several of
a.m.
them.
Oh,
So I don't know if he's still down
From
there,
2003.
Nick took him from the magistrate's
So-
office,
I was
Um,
mistaken since 2000.
but he was advised to come back up here when he's done, so hopefully.
Who is that?
Jackson Wade,
Jalen Jackson.
Jalen Jackson Wade,
Oh, so he can be arraigned.
and yeah.
Judge,
so he
January
got
11th
fingerprinted.
at 9.
January 11th at 9.
Yeah, I was in 2023.
Probably January 11th at 9.
Thank you.
You're welcome. Okay, and then
Yep.
someone scratched out. Okay, Levy is continue.
Yeah.
And then are we doing a plea on Calvin? Or is he already in warrant status?
So, the reason this was, Mr. Calvin's matter was adjourned was because part of the plea was a dismissal of a misdemeanor file that hadn't been sworn to yet. I believe the misdemeanor file was sworn to on Monday, and that's where the warrant status would be. So I believe, after conversation with Ms. Robinson, he will be here. So all he would need to be is arraigned on that misdemeanor file, and then that can be dismissed as part of the plea. And I have that file number for
I
you.
have it here too. I
Okay.
just was making sure I wasn't tripping just because it's literally one number off from the felony file. So 2303-121 is the felony, 23-03421 is the misdemeanor, so. It's lucky day. We'll take care of that when he gets here, and then Purnell. Is Purnell present?
Mr. Palmer said they're leaving that on.
Mr. Russell,
Yes.
your attorney is logging in to speak with you now, okay?
Okay, thank you.
You're welcome.
Mr. Russell, you're all set for today.
Okay, thank you.
You're welcome.
Have a good day.
You too.
It's okay, Mama. I love you. It's okay. It's this. I know. You can't help it. Okay, it's okay. All right. You gotta take your medicine. Okay.
Ms. Boland, I'm gonna put you in the waiting room until I'm ready for your case, okay?
Yes, Your Honor.
Let's see. Did Jalen Jackson Wade return?
Yes.
Okay. On the record in the matter of the people of the state of Michigan versus Jalen Jackson Wade, file number 23-03330. FY, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor. Jacob Riley on behalf of Mr. Jackson Wade.
Okay, Mr. Wade, today was the date and the time that was set for a probable cause conference. In a matter where you have one count of weapons carrying concealed and another count of weapons carrying concealed. The matter is scheduled for preliminary examination on November 22nd at 9 o'clock in the morning in person at the court. Are we continuing to exam?
No, Your Honor, Mr. Jackson Wade intends to unconditionally waive this right to preliminary exam.
The people waiving as well?
Yes, Your Honor, the people would waive their right to exam. However, we would be seeking to bind over on an added count 3. And I've let the defense know this as well. And I believe they're still going to waive with the added count 3, Your Honor. That is correct. And that would be, the people would be asking for bind over on counts 1 and 2 and an added count 3 of weapons, firearms, possession of a loaded firearm in or upon a vehicle. And that is on PAC code 750.227C.
I also have here people of the state of Michigan versus Jalen Jackson Wade, file number 23-03297. In this matter, sir, I have a felony complaint. It alleges that on or about September 20th, 2019 through March 2nd, 2020 at the area of 1535 Indiana Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law, commit the act in count 1 of false pretenses, 1,000 or more, but less than 20,000, and that you did allegedly, with the intent to defraud or cheat, make use of false pretense to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having the value of $1,000 or more, but less than $20,000. Now, this was contrary to Michigan Compiled Law 750.2184A. That's a felony. Maximum penalty is 5 years and or $10,000 or 3 times the value of the money or property involved, whichever is greater. There's also a count 2 of computers using to commit a crime, maximum imprisonment of 4 years or more than less than 10 years, alleging that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit false pretense, $1,000 or more, but less than $20,000, contrary to Michigan Compiled Law 752.796 and Michigan Compiled Law 752.7973D. That's a felony, maximum penalty 7 years in prison and or $5,000. Reimbursement to the government for expenses incurred in relation to the violation in the manner indicated by Michigan Compiled Law 769.1F, and a consecutive sentence may be imposed for the underlying conviction. There's a count 3 of attempted false pretenses, $1,000 or more, but less than $20,000, alleging that you did attempt to commit the following listed offense and in the attempt did act towards the commission of that offense, but failed in the perpetuation or was prevented in the execution thereof, contrary to Michigan Compiled Law 750.92, and that you did allegedly with the intent to defraud or cheat, make or use a false pretense to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having the value of $1,000 or more, but less than $20,000, and that this was done contrary to Michigan Compiled Law 750.2184A. That's a felony. Maximum penalty is 5 years in prison. The court shall order law enforcement to collect DNA identification profiling sampling. Do you understand the charges read in counts 1 through 3 and the maximum penalty attached to each? You have the right to be represented by counsel. Mr. Raleigh is here because he represents you on the other matter, and he is here for the purposes of your arraignment on this file today. You have the right to have an attorney represent you at each stage of the criminal prosecution, and you also have the right to have an attorney represent you if you are questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way through to a trial. This is a matter in which you are being charged with 3 felonies. That means you have the right to preliminary examination, and you have the right to have that examination within 21 days of today's date. At the time of your examination, you have the right to require the prosecution to meet their burden of establishing that they have sufficient probable cause, that a crime was committed and probable cause sufficient to charge you with the crimes that they've alleged you've committed. You have the right to proceed to a trial. At the time of trial, which you have the right to jury trial. You have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront in court and cross-examine any of the witnesses that the prosecution intends to call against you. You have the right to call your own witnesses to trial or present evidence that you believe further defense of the charges being brought against you. You understand all of these rights? Do you have any questions so far? Is he requesting court appointed counsel?
He is.
The court will enter a plea of not guilty on your behalf at this time. What's your address?
1535 Indian Avenue. And Michigan 4906.
Your phone number still ends in 2217. You're still a full-time truck driver. I'm gonna set your matter for probable cause conference. I don't think that, yeah, I don't think.
I just wrote her to see if she can schedule to PCC.
Who?
Susie Craig. The clerk has to do that.
Okay, we're gonna have it scheduled for a probable cause conference and preliminary examination. The criminal department is taking care of that as we speak. And we'll get you a copy of those dates. Concept bond at 2,000 personal recognizance. While out on bond, you have the following conditions. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to engage in any assaultive or threatening behavior. You're not to travel out the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon, and you need to report to pretrial services within 48 hours of today's date, okay? And you're already reporting, I believe, on your other matter, correct? Okay. Do you have any questions at this time? Probable cause conference is going to be November 30th at 8:30 in the morning. You can appear via Zoom for that, okay? Your preliminary examination is scheduled for December 7th at 8:30 in the morning. That's in person at the court, okay? Do you have any questions? Okay, now as to the other file that you were already here for your probable cause conference, again, you have the right to have a preliminary examination in this matter. And you have the right to require the prosecution to establish the minimum burden of probable cause. And that is more than mere suspicion that a crime was committed and more than mere suspicion to charge you with that crime. Do you understand that? Do you wish to unconditionally waive your examination? Okay. Anybody threatening you to get you to waive your exam? Any promises being made to you in exchange for you waiving your exam? You're waiving it freely and voluntarily. The bind over date is going to be November 29th. That's the date that the circuit court gets the file from the district court. That's not a court date for you. You do not need to appear, okay? Your next court date will be in circuit court, and that will be a pre-trial, okay? Your attorney will be made aware of that date. You stay in contact with him. We have to sign that. Okay. Bond set in this file is $2,000, personal recognizance, and all the same conditions that I just posted on your current bond. That will continue. Do you have any questions on this file? Any additional matters for the record, counsel?
Nothing from the defense room.
Nothing from the people here.
Oh, you're all set, sir. Thank you. On the record in the matter of the people of the state of Michigan versus Shawan Calvin, File number 23-03121. Council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Karen Robinson, Assistant Public Defender for Mr. Calvin.
Okay, and Mr. Calvin, I also have the people of the state of Michigan versus Shawan Calvin in file number 23-03421. In this matter, I have a misdemeanor complaint. It alleges that on or about July 14, 2023, at the area of 1111 Leonard Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of domestic violence. It alleges that you did make an assault or assault and battery upon a Kynesha Chappelle Embry, an individual with whom you had a dating relationship, and that this was done contrary to Michigan compiled law 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge and the maximum penalty, sir?
Yes.
You have the right to be represented by an attorney in this matter. If you cannot afford to hire an attorney to represent you, you can make a request in this file to have the public defender's office represent you at the expense of the public. You understand that? Are you requesting court-appointed counsel?
Yes, ma'am.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way to trial. You have the right to a trial, and you have the right to jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that? You have the right to require the prosecution to prove your guilt at trial by proving each element of the charge of domestic violence beyond a reasonable doubt. You have the right to confront in court and cross-examine any of the witnesses that the prosecution calls against you. You have the right to call your own witnesses to your trial or present evidence that you believe further defense to the charge being brought against you. You understand that? You have the right to remain silent at trial and not have silence be used against you. For the purposes of your arraignment, we'll enter a plea of not guilty at this time, okay? The matter will be set for a pre-trial. On in this matter, 500 personal recognizance with a no contact order in place for the protection of the alleged victim, that being a Kynesha Embry. That's the same victim from the felony file that we're on here today. So all those same conditions will apply on the new file, okay? While out on bond, you're not to be within 1,500 feet. You know, your other bond says 2,000, I do 1,500, 2,000's way too far. Way too, you have to be within 1,500 feet of wherever she lives, works, or goes to school. Do you understand that? You're not to be within 1,500 feet of wherever she is, period. Do you understand that? You're not to have contact directly or indirectly with Kynesha Embry. Do you understand that? You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. And you're not to engage in any assaultive or threatening behavior. Your phone number still ends in 7517.
Say it again, though?
Your phone number ends in 7517.
Yes.
You're still at the address on Ronald?
Yes, ma'am.
Are you employed?
Not right now, no. Not right now, at the moment.
That's private.
Yeah.
Okay. Here I have a plea sheet. That says the people are offering on the felony file for you to plead to count 2 of domestic violence and an added count 3 of attempted police officer assaulting, resisting, obstructing, and exchange. They're going to dismiss count 1. They're going to dismiss the habitual notice. And then also, they're going to dismiss this file that I just arranged you on. That's a complete and accurate understanding of the plea offer.
Yes, it is, ma'am.
Okay. And so I have an advice of rights and plea information sheet with today's date on it. You review these rights.
Yes, ma'am.
Okay, and that's your signature.
Yes, ma'am.
You understand these rights.
Yes, ma'am.
Do you have any questions about them?
No, ma'am.
You want to give them up today in order to enter a guilty plea to count 2 of domestic violence and an added count 3 of attempted police officer assaulting, resisting, obstructing. Raise your right hand. Your other right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay. And we just went over some of these rights, but I just need to make sure you understand that these are rights that you need to give up in order to accept this offer. So again, you have the right to a trial, and you have the right to jury trial, and you have the right to the presumption of innocence. So you're innocent until proven guilty. And in this felony file, you have the right to require the prosecution to prove your guilt by proving each element beyond a reasonable doubt. You want to give up all of those rights.
Yes, ma'am.
You have the right to remain silent at your trial and not have silence be used against you. You have the right in this matter to confront any witnesses in court, cross-examine them, or present evidence at court that you believe further defense to the charge, or charges brought against you. You understand that?
Yes, ma'am.
Are you willing to give those rights up?
Yes, ma'am.
Anybody making any promises to you to get you to waive your rights and plead guilty?
No, ma'am.
Any threats being made to you for you to waive your rights and plead guilty?
No, ma'am.
Are you currently on probation or on parole?
Nothing, ma'am.
Okay. You don't have any other matters pending other than these 2?
No, ma'am.
Okay. You understand that a guilty plea can result in a conviction that may have impact on any travel or immigration status that you may be seeking, like you may want to go on vacation to Canada. You don't understand that?
Oh.
So a guilty plea and you get a criminal conviction, some places don't let you visit them if you have a criminal conviction. You understand that? Okay, and you're okay with waiving your rights with that understanding?
Yes, ma'am.
Okay, you also would have to report or may have to report a criminal conviction on your job applications, and it sounds like you should be looking for a job right now, correct?
I'm in the process now.
Okay, so you understand that a guilty plea could be something that you need to report to your employer or a future employer.
Yes, ma'am.
Okay. As to count 2 of domestic violence and file number 23-03121, how do you plead?
Guilty, ma'am.
As to added count 3 of attempted police officer assaulting, resisting, obstructing, how do you plead?
Guilty, ma'am.
And you're pleading guilty because you believe you're guilty?
Yes, I'm guilty, ma'am.
Factual basis, please.
Yes, Your Honor. On October 11th, 2023, were you present at the address of 4425 Chadburn in the city of Lansing, state of Michigan?
Yes, ma'am.
Okay, and was there also a Kynesha Embry at that location?
Yes, ma'am.
And were you previously in a intimate relationship with Ms. Embry?
Yes, ma'am.
Okay, and on October 11th, was there a physical altercation with you and Ms. Embry that occurred?
Yes, ma'am.
Okay, and you hit her in the face, is that correct?
Yes, ma'am.
And that was not done in self-defense?
No, ma'am.
And then, did you have an incident with police on October 12th, 2023 at the area of 1111 Larned Street in the city of Lansing, state of Michigan?
Yes, ma'am.
Okay, and at that time that you had an interaction with police, you knew that they were police officers who were dressed in uniform, correct?
Yes, ma'am.
Okay, and then when they attempted to stop you and arrest you, you attempted to walk away and pull away, is that correct?
Yes, ma'am.
Any questions for you, Mr. Brodowitz?
Nothing from the people, Your Honor.
Are satisfied with the factual basis, I'll accept your plea. Find your plea be made freely, voluntarily, and intelligently. This matter is set for sentencing. It's going to be on January 11th, 2024. When you leave here, sir, you need to go down one floor to the 5th floor so you can check in with the probation department so they can get you set up for your pre-sentence interview, okay?
Set a floor again, ma'am.
The 5th floor.
The fifth floor, okay.
Yep, one floor down. You'll do that immediately upon leaving here today. Do you have any questions at this time?
No, ma'am.
You may appear for Zoom for your sentencing. You just need to have video and you need to be in a quiet space appropriate for a court proceeding, okay?
Yes, ma'am.
Any additional matters for the record, counsel?
Judge, did you say the time for the sentencing?
9 a.m.
Thank you.
No problem. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
You're all set. Mr. Groen, which matter are you?
I am here on the LVNB funding Catherine Boland matter, Your Honor.
Okay, she is present. I'll put you both in a private meeting room so you all can discuss this matter while I handle some criminal matters.
Okay.
Did Laughter cancel their discovery? I don't see Mr. Mills.
Yeah, he's got 2 cases. Let me see if I can find it for you.
Yes, it looks like it.
Okay, thank you. Six. We're waiting for Mr. Mills. Mr. McFadden was continue. No, Mr. McFadden did not appear. What Russell was continue. And then that brings us to 10 o'clock. Last few didn't, they canceled. Boland is present.
And Mr. McFadden never appeared.
Mr. McFadden was already in warrant status. He did not appear.
Okay. Ms. Wonky told me we're leaving that out.
For McFadden?
Yes. I'm
No.
not sure if she had phone contact with him, but
No, he didn't appear.
okay.
And then Mr. Abbott is here. Is Miss Lee in custody?
She is in custody, Your Honor. She was not transported and hoping to be able to do this plea by phone. Again. Not transported. I
Did we see her
checked.
this week?
I checked around 9. I can check again.
We just saw her this week on another matter. I don't know why she was not transported, but.
Lansky is in custody and she is.
Wolanski's in custody and she needs to be brought up. Are we running an exam?
We have, I think he has one more.
It'll be,
witness.
yes, it'll be a continuation. When I came back in here, I did not see the. And. Got, so 6 minutes, but I need to go see. Plan is to continue.
Oh, here we go. Got it. Why did you think I was confused? Let me see. Oh, you were. And then. Lee is in Ingham County.
Yes.
Okay, let's see if we can get someone to call them and have them put.
She's scheduled for time.
Oh, at what time?
At 10:30.
Oh. Now, Ms. Lee, your attorney is logging in now.
Okay.
On the record in the matter of LVNV Funding LLC versus Catherine Boland, file number 21-02977 GCE, council appearance.
Good morning, Your Honor. Brian Gruen, GROENP number 56673 on behalf of plaintiff LVNV Funding.
Thank you. And then Ms. Boland is present via Zoom. Ms. Boland, state your name.
Catherine Boland.
Okay, you don't have an attorney, correct?
I have bankruptcy attorney Mars and Terry. We've discussed it though.
Okay, Mr. Growing, how are you all proceeding? Are we handling the objection to
Your Honor,
garnishment, or have we come to resolution?
we have not come to a resolution. I think Ms. Boland understands that her objection, there is no really valid exemptions to a state tax guard, but she has informed me that she has retained Michelle Mars to file a Chapter 7 bankruptcy. And so this is regarding a new state tax guard that's not going to take effect till next April when the tax returns are filed. And it sounds like she's going to be filing bankruptcy well in advance of that date. And then once that bankruptcy is filed, the automatic stay will be in place that would cease any type of collection. So I told her as long as the bankruptcy is filed, this state tax guard will have no force or effect. But that for today's purposes, especially since the court's already ruled on the same objections back in October, that there is no valid objection to our state tax guard, we would just ask that Ms. Boland's objections be denied.
Okay, Ms. Boland, did you want to respond? I muted you because of the background noise.
Yes, ma'am. I'm sorry. I have a special needs child. I'm sorry. Unfortunately, there's nothing else further I can do until she gives me a bankruptcy number. I did speak with her yesterday. She said she has to go over the 12 pages that I signed to make sure I signed every one of them the right way. Everything has to be signed appropriately, and from there she will give me the bankruptcy number, and I guess I have to inform you guys. So I have retained her. I did pay my retainer and everything, so she's paid. It's just the filing now and going over the paperwork.
Okay, so once that's filed, you'll notify our clerk's office and they'll send me an order for administrative stay of this case. But as to the actual objections that you're making, what the plaintiff's attorneys has stated is accurate, that, and we've gone over this not just in the previous hearing on this file, but we went over this maybe last week or the week before, that there's
good
no
memory,
valid
Your Honor.
objection.
Yes, ma'am.
Yeah, to the income tax garnishment. So for that reason, your objections are denied, okay?
Yes, ma'am. I understand now.
Okay, so do you have any questions at this time?
No, ma'am.
You are all set for today. Thank you.
Have a great day.
You're welcome. Thanks, Mr. Meltz. Yeah, they had it in on the record for it. Mr. Meltz still on the record?
I can check.
Here's Mr. Meltz.
Sorry.
On the record, in the matter of the people of the state of Michigan, Since we get a prosecutor. First is Carrie Curtis. Trial number 23-03378.
Yeah, the prosecutor not here, I'm just moving for dismissal.
Yeah. Can you do me a favor, see if the prosecutors in that room?
It's usually in the jury room. Counsel can have your appearance.
Jeff Prados on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Curtis, who is present and seated to my right.
Okay, today was the date and the time that was set for a probable cause conference and possession of narcotics. Matter scheduled for preliminary examination November 22nd at 9:30 in the morning. Are we continuing to exam?
If I may, Your Honor, at this time, the defense would be requesting, I don't think there's going to be an objection to a waiver of the 21-day rule in setting the preliminary examination beyond the 22nd. The defense is looking into a potential witness in this matter and further gathering information and discovery. And we would like a little bit of additional time. I don't think people would be objecting to that.
No, there'd be no objection from the people to wait the 21 days, Your Honor.
Okay, Mr. Curtis, do you understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned?
Yes.
You were arraigned on November 10th, and due to the fact that your attorney is seeking to gather potential witnesses and help you formulate your defense to the charge, are you willing to waive the 21-day timeline?
Yes.
Anybody threatening you to get you to waive that timeline?
December 28th at 10.
December?
Yes.
December 28th at 10. Do you have any questions today, Mr. Curtis? Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you, Your Honor.
Make sure your notice to appear, you'll be all set, okay? You're welcome. Did they give me this for Miss Abernathy because she had a civil matter today? Is that what we
Yeah, she
had?
had 2 warrants. I put the file in here, but
Got it. Is she set for arraignment on this? We can set it for arraignment. Oh, no, she should be in one.
I think that one is, she never appeared.
She never appeared. She wouldn't need to appear because it's assaulted. She should have a warrant for it already.
They never started on arraignment date.
No, they don't need to. It's assaultive, so it
Oh, okay.
gets, it's signed a warrant immediately. Is Jeremiah Marcos present?
Yes.
On the record in the matter of the people of the state of Michigan versus Jeremiah Marcos, file number 23-02623. Appearance, please.
Jeff Prados on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Marcos, who is present and standing to my right at this time.
Okay, Mr. Marcos, today's the date set for a probable cause conference. He adjourned this. He was eligible for mental health court. What were we adjourning for?
And Your Honor, at this time, I would believe that he is legally eligible. I believe we're still waiting on whether or not he's clinically eligible. Is my understanding correct?
Yes, I have received nothing to that effect yet, Your Honor.
But being that this case has been pending for a little bit, I'll continue talking with Mr. Barlow, Your Honor. Obviously.
Okay, so how much time are you looking for?
Next week's kind of a crazy day. We can maybe set it out for 2 weeks. There's time in early December.
Just right review. What are we doing it for? Like we running an exam or are we just doing a review date?
Yeah, review date.
December 7th at 9.
December 7th at 9. Yes,
Thank you.
no problem. I will get you a copy of your notice, sir. Any additional matters for the record today?
Nothing from the people, Your Honor.
No, those pass. Thank you again.
Thank you, you're all set. Let's see.
What's that?
On the record in the matter of the people of the state of Michigan versus Deonis Marie Lee, file number 19-04330 and 19-04332, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney John Abbott representing Deonis Lee. We're appearing by video today.
All right, well, today's the date and the time that was set for a plea in both matters. I have a plea sheet, Ms. Lee. The people are offering for you to plead to an added count 2 of motor vehicle unlawful use, first offense notice, and that you would pay restitution in the amount of $633.73. In exchange, they'll dismiss count 1 and file number 19-04330. Do you understand that offer?
Yes, ma'am.
And did you want to accept it today?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down, ma'am. You have the right in this matter to proceed to a jury trial. You have the right to the presumption of innocence in this matter. So you're innocent until proven guilty. Do you understand that?
Yes, ma'am.
Do you want to waive your presumption of innocence to enter a guilty plea?
Yes, ma'am.
You have the right to require the prosecution to prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You have the right to cross-examine or question any other witnesses that the prosecution intends to call against you at your trial. And you have the right to call your own witnesses to trial or present evidence that you believe show a defense to this charge. You want to waive those rights as well, ma'am?
Yes, ma'am.
Is anybody making any threats to you to get you to waive your rights and accept this offer?
No, ma'am.
Any promises being made to you if you waive your rights and enter a guilty plea?
No.
Are you currently on probation or on parole?
No, ma'am.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer, or you may need to report this conviction on a future job application?
Yes, ma'am.
You also understand that a guilty plea could result in a conviction that may have impact on travel or immigration status?
Yes, ma'am.
Okay. As to count 2, motor vehicle unlawful use, first offense notice, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes, ma'am.
Factual basis, counsel.
Thank you. Ms. Lee, thinking back to August 2nd of 2019, were you at a location 909 East Jolly Road in the city of Lansing?
Yes, sir.
And that's in Ingham County, Michigan?
Yes, sir.
And there was a man there named Jeffrey Howenstein. Did he give you permission to use his car?
Yes, sir.
And he expected you to bring that car right back when you were done using it?
Yes, sir.
But you never brought it back?
Yes, sir.
Okay. Thank you, Your Honor. I think that's the factual basis.
Any questions?
Nothing from the chief. Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently.
Thank you.
No problem. Do we have our victim here at all?
We do not. Your Honor.
The matter will be set for sentencing.
Your Honor, we have an agreed upon restitution amount.
Yeah, well, there's a victim, so I have to give him an opportunity to speak.
Okay.
Should he wants to. I'm not gonna refer to probation.
Your Honor, may I address the issue of bond?
November 30th at 8:30.
Thank you.
Yes, you can address bond.
Thank you, Your Honor. Obviously, the defendant has pled to a misdemeanor and the felonies have been dismissed. She's pled to a 93-day misdemeanor. My calculation is that she's been in jail for 43 days. She did 7 days when she was originally arrested back in January of 2020. And then she got arrested again this year on October 12th. She's been in jail since October 12th. I'd ask the court to grant her a personal recognizance pending sentencing, Your Honor.
Thank you. Personal recognizance is intended for people who are responsible enough to return to court on their own. And so this matter has been pending since 2020 because Ms. Lee won't come to court. She failed to appear February 7th, 2020. Bench warrant was issued. In March 2021, she shows up and she said she honestly doesn't have a reason why she didn't show up to court. Whoa, I'm talking. Then I reset the matter. She again fails to appear. Only 1 week after she came to court and said she didn't really have a reason why she missed it. So she failed to appear, and then we don't see her again until 2023. And then she says she doesn't recall. And so what is it that's gonna make me believe that she's gonna come back for sentencing? Ms. Lee, did you have something you want to say now?
Yes, I've been through a lot. I've been going in and out of the hospital for open heart surgery, and I was using drugs at the time. I've been clean and I'm trying to change my life. So
I appreciate that you're being honest about what is causing you or what has caused you to miss your court dates in the past. And I sympathize with your situation. I would love to see you clean and sober and being a positively contributing member to this society. But the first step of you doing that is you resolving these matters. And so you've taken a plea to a misdemeanor, which is a huge step there. But if you don't return for your sentencing, then you're gonna have a bench warrant, which is gonna just continue this lingering over you. Do you understand that?
Yes, ma'am.
Okay, and I'm gonna be honest, I don't have any reason at this point, based on the age of the case and the offer, to sentence you to a term of probation. It was my intent to credit you time served, but due to the crime victim right, there's a victim in this matter, so I gotta set it for sentencing so he can have an opportunity to address the court if that's what he wants to do, okay?
Did he not show up today? Is that?
He was not required to show up today. It was set for a plea.
Okay, because the other 2 weeks ago, I was supposed to come into court and he came and they brought the wrong person. So I'm still sitting here.
I understand, but I'm just worrying about you coming back to court when you're supposed to. And I just gave you a sentencing date, November 30th, okay?
Okay.
You don't even have to appear in person. You can appear via Zoom if you have a phone with a video.
Yes,
okay?
ma'am.
Bond is set at 500 personal recognizance. You need to follow all your previous bond conditions, and you need to make sure you appear to your sentencing, okay?
So I'm not getting PR bond. I have to come back November 30th at 8:30, right?
That's correct, ma'am.
Okay.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
Thank you, ma'am. I'll see you November 30th.
Thank you. I do have a nollie for the other file.
This right here.
I don't have a file for some reason. You're good to go, ma'am. Thank you.
Thank you, Mr. Abbott.
And then we can bring Walensky up, or we'll have security bring him up.
Yep, right on that, Judge.
Thank you.
You're welcome.
Were either of you waiting for a matter? Oh,
I'm
okay.
not,
I was gonna say, I don't see it on my docket.
You said Walensky, Judge?
Walensky, yep.
Got it.
I wasn't here for that. I just did. Oh my God.
Your support section. Yeah.
Yes, they're bringing her up.
She says, she didn't know police officer but only minutes on the cell phone. So I guess it's a kind of announce in this emergency situation. She showed up this morning and started talking to each other. I can't imagine. But then the prosecutor was escorting somewhere near me, and she started talking to him this time.
Coffee?
Yeah, so
Starbucks?
wait and see if you want to go. That's yeah. Whole concert hall, student.
Okay.
You were right. What the heck?
Dude, I like it.
All right then. There you go.
Oh, yeah.
Just waiting for Ms. Nash to return.
No.
I got her 17. She did her stair straight thing.
Yep.
Followed the agreement. She did the stair straight and on sheets. Some of the so he was getting the job. So they served, you know, that's the just push out like this.
Yeah, they just walk up in the back.
Do all that in the back. Maybe that's part of the school straight by doing it.
No, they say that you want to do that. Wait, have to run for that too, or just do that.
Row and McLaurin.
Yeah.
Yes, we can do it. We don't have to go election. We can do it right after this.
Okay. Yeah, it's like.
They tax somebody.
Yeah, they're gonna be. Don't say anything. Just listen.
Everything went like we talking about except she did say no.
Oh.
But she let him go to Georgia, she couldn't go to the so jail. I think they the county exception when you do that.
How are we going to?
On the record, in the matter of the people of the state of Michigan versus Teresa Wolanski, file number 23-03152FY, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Ms. Wolanski. She is standing to my right.
Okay, today's date that was set to continue a preliminary examination that started on the 3rd of November. My understanding, we were continuing this for the testimony of Officer Uberoff.
Yes,
Okay, and we're ready to proceed at this time?
yes.
Okay, any preliminary matters before we call our witness?
I believe last time there was a sequestration order, but I do not see any witnesses in the courtroom. I would just ask that continue.
Sequestration is granted and continued. Any matters for you?
No preliminary matters from the defense. Thank you.
Thank you. You can call your witness.
Thank you, Your Honor. People call Officer Bailey Uberoff.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you, officer. You can have a seat. Please state your first and last name and then spell both.
Officer Bailey Uberoff, Bailey, Uberoff is Ueberroth.
Would you proceed, counsel?
Thank you, Your Honor. Good morning, Officer Uberoff.
Morning.
Officer Uberoff, how are you employed?
As a police officer with the city of Lansing,
And how long have you been a police officer with the city of Lansing?
5 years.
Okay. And were you working in that capacity on October 16th, 2023?
Yes.
All right. And on that date, did your duties take you to the address of 733 Community Street?
Yes.
And is that located in the city of Lansing in Ingham County?
Yes.
Okay. And why were you dispatched to that location?
For a missing child complaint.
Okay. And when you arrived on scene, what did you observe?
Observed several officers escorting a female out of the residence in handcuffs, yelling.
Okay. And when you got there, how did you proceed?
I informed the officers I would be taking custody of the female for interview purposes.
Okay. And did you learn the name of the female?
I did.
And what was that?
Teresa, excuse me if I get this wrong, but Orlansky.
I believe that's close enough. Do you see, I believe it's pronounced Wolanski, but do you see Miss Wolanski in the courtroom here today?
I do.
And can you please identify where she's sitting in an article of clothing she's wearing?
Right over there in the blue jumpsuit.
At this time, people would move, or people would ask the record reflect that the witness has identified the defendant.
No objection, Your Honor.
Identification is noted for the purposes of preliminary examination.
Thank you, Your Honor. So Officer Uberoth, after you took custody of Miss Wolanski, how did you proceed?
I introduced myself as a police officer and informed her that I wanted to question her, but not before doing so, I had to read her Miranda rights.
And did you read her Miranda rights?
I did.
Okay. And did she waive those rights?
She did.
Okay. And did Miss Wolanski tell you what happened?
She did.
All right. And what did Miss Wolanski tell you had happened that early morning?
She said an unknown hour in the early morning, she went over to the QD to go buy medicine. She realized they didn't have it. She was driving back home to 733 Community when she saw a child in the road and had to slam on the brakes to avoid the near miss collision. She said she exited her vehicle, made contact with the child, saw that no parent was around and that his hands were pulled to the touch. That the child wasn't saying anything, so she was going to put her in her vehicle to warm him up and drive right down the block to 733.
All right, and did she say what happened after she arrived at 733 Community?
Yes.
And what did she do when she arrived?
So she brought him inside, up into the attic rather than like a bedroom or a living room, and then she said she Googled what to do.
Let me pause you right there, officer. Did Miss Wolanski say why she took the child into the attic?
She said that was the only space available.
Okay. So what happened after that?
She said that she Googled what to do if she located a missing child. And in addition, she texted her sister asking what to do.
Okay, and in your conversations with Ms. Wolanski, sorry, let me rephrase. In your conversations with Ms. Wolanski, did you ever ask if she attempted to call 911?
I did.
All right, and did she attempt to call 911?
She said she was going to, but never did.
And did she say why she didn't?
She said that the child began to scream for his mom, so she gave him the phone, and also stated that if she were to call the police, she believes that the police just make the situation worse.
Okay, and what did Ms. Wolanski say happened after that?
The police arrived, or she fell asleep, and the police arrived.
Okay. During your time at 733 Community, did you ever have a chance to view the house?
I did.
And why did you have to go into the house?
She asked me to retrieve additional clothing items for her.
Okay. And when you can you please describe for the court the condition of the house?
Yeah, it was filthy.
Relevance. There's an objection to relevance. Did you want to respond?
Yes, Your Honor. I believe this would go to where I'm going with this would go to the credibility of the defendant's story to the officer and establish going to establish probable cause for the elements of the charge, Your Honor.
Credibility of the defendant's statement to the officer?
Yes, sir.
Which element of the charge involves how clean the house was?
I'm trying to understand how the condition of the house said anything. Are you trying to establish, well, corroborate the statement about that was the only place to take the child?
Yes.
Oh, okay, okay, I'll overrule the objection.
Okay. I can rephrase the question to you, Your Honor, just so it's when you got to the house, was there when you entered the house, was there anyone else in the house?
Yes.
Okay, and where was that individual located?
On a bed just after you walk in the house.
Okay, and where did you retrieve the clothes for Miss Wolanski from?
There was an additional bedroom within the residence on the main floor.
Okay. And was anybody occupying that bedroom at that time?
No.
Oh. And then, so Miss, obviously you brought up, Miss Wolanski told you that she contacted, or that she Googled some stuff about what to do when you find a missing child, and she said she contacted her sister, correct?
Correct.
All right. Did you ever receive any verification that she did this?
No.
Okay. Did you attempt to verify that she did this?
I did.
And how did you do that?
At the conclusion of this incident, Ms. Wolanski was arrested and transported to LP lockup. At that time, she requested I contact her sister over the phone with the number she provided me, just telling her that she's been arrested. And that's when I had the opportunity to speak with her sister.
Okay, but let me back you up to during the incident. Did you ever attempt to verify what Ms. Wolanski was telling you at that time?
Just a moment.
Yeah, I can put it down, please.
Continue.
All right. Do you need me to repeat the question?
Yes, please.
Okay, so during your time at 733 Community while you were interviewing Ms. Wolanski, did you ever attempt to verify what she told you at that time?
Yes.
And how did you attempt to do it at that time?
I requested consent to view her cell phone.
And did Ms. Wolanski provide you consent to view her phone?
She did not.
Okay, and did she say why?
I don't.
Okay. Second round. No further questions at this time. Your Honor.
Cross exam.
Thank you. Morning.
Morning.
See you.
As well.
So, you observed the child when you were there?
I did not.
Okay. You mentioned that you looked in a bedroom on the first floor for some clothing.
Correct.
Did you try to turn the lights on?
I went in with another officer. I just used my flashlight. I don't remember if I actually attempted to use the lights.
But there was no lights on in that room, correct?
Correct. The lights were on.
Okay. And you didn't try turning them on? Or you did and they didn't work?
I don't remember.
Okay. So you called the sister?
I did.
And she told you that she'd been contacted by a text message or a voicemail or something?
Correct, the text message.
So that Ms. Wolanski had contacted her sister earlier that morning?
Yes.
And had questions about what to do if you find the lost child?
Correct.
But the sister never got back to her because she was asleep when the message came in?
That's correct.
And the timeline here is somewhere around, I'm not sure when the call came in, around 4 a.m. that the missing child complaint started?
I believe that's accurate.
At this time, Your Honor, I would object to hearsay as to what the sister said. It's not statements of a party opponent.
Your Honor, it's not offered for the truth of this assertion. It's offered for the fact that she contacted her sister. And one of the elements of the crime is that she's trying to keep everything secret. So it's not important what she said, really, other than the fact that she
I'm
contacted
trying
her.
to confirm that she did in fact contact her sister. Okay, the objections overruled.
Where were we? You remember?
Text message. That's it.
So, so there was some kind of communication about the child being found.
Correct.
And that she had the child with.
Correct.
And that's consistent with the story she told you. That's the story that Ms. Wolanski told you when you interviewed her in the back of your car.
Correct.
And she found the child in the street and brought him home.
Brought him to her home, yes.
Right. And when the child was found, he was up in the attic?
To my knowledge, yes.
Okay. And Ms. Wolanski was asleep in the attic?
To my knowledge, yes.
Nothing further from this witness, Your Honor. Thank you.
Redirect.
Yes, just briefly, Your Honor. So you stated in your cross-examination that the person, I guess, identified as Ms. Wolanski's sister, said she received a text message from Ms. Wolanski, correct?
Correct.
All right. And did you ever request proof of that message?
I did.
How did you request proof of that?
I requested that sister provide me it through text message or email with my partner, cell phone.
Okay, and did you provide the individual you were speaking to with that information?
I did.
Right, and did you ever receive any proof of that message?
I did not.
Okay. No further questions, Your Honor.
This witness be excused.
Yes, Your Honor.
Your Honor, can I ask him a couple of questions based on that inquiry?
The inquiry about whether or not he ever received proof from the sister?
Correct.
How is that beyond the scope of your cross?
So far that the purpose of him asking the question is to suggest that the call wasn't confirmed. Or that the call wasn't made. That there was some other way that she could have gotten that information.
You're gonna ask this witness that question?
That's the reason he was asking those questions that weren't part of his original direct.
Right, but he wouldn't have asked if you hadn't asked about whether or not he had confirmed whether or not there was a text message or communication. So he was following up on your cross.
Right.
That's the purpose of the redirect.
Thank
So
you.
if I let you do that, then I gotta let him redirect again.
Mind you, I
Thank
withdraw
you.
my request.
Thank you. May this witness be excused.
Yes, Your Honor.
Thank you, Officer Roth.
Thank you.
Any other witnesses or evidence?
Nothing from the people, Your Honor. People will rest at this time.
This is defense calling witnesses.
No, thank you.
Okay, you can proceed to argument.
Thank you, Your Honor. The people would ask that this be bound over to the circuit court as charged in the complaint. We heard over the 2 days of this exam testimony from Officer Sam Candell, Officer William Turbo, and then on the second day, Officer Bailey Uberoff. On the first day, we heard testimony, as I stated, from Officer Candell, that he was called to a report of a missing child, that they searched around the area of that child's home until they received another call and were redispatched to the area, to the address of 733 Community Street, which is located in the city of Lansing in Ingham County. When Officer Candell arrived at that location, he advised that he entered the residence. He then proceeded, was directed by an individual in the residence up into the attic through the closed, that the attic door that he had to enter through was closed. When he entered in through that door, he saw the child, which I believe we also saw from his body cam submitted, I believe it's Defense Exhibit A, and that he retrieved the missing child from the attic at 733 Community Street. We heard testimony from Officer William Turbo that when he responded to the same call, to the same address, that when he arrived, he went up to the attic and found a female asleep who I believe he identified as the defendant, though he did not have a name, if I remember. And that at the time when he observed and took pictures of the attic, the only exterior access into the attic was covered by a blanket, and that the stairs leading up to the attic were quite steep and were very narrow going up there, and that it was not not a very safe stairwell, Your Honor. We then heard testimony from Officer Bailey Uberoff, who positively identified the defendant here, Ms. Teresa Wolanski, and who took her statement after this incident. He testified that Ms. Wolanski found the child after coming back from the store, and that she took the child into the house, took him up into the attic because it was the only space available, and that she then fell asleep. And that was when she was awoken to police in the house, Your Honor. And as I said, the people would ask that this be found over as charged in the complaint. First element of unlawful imprisonment is that the defendant knowingly restrained another person. And to restrain means to forcibly restrict that person's movements or to forcibly confine the person as to interfere with that person's liberty without the person's consent or without lawful authority. Here, the people would say that they proved beyond with probable cause evidence that Ms. Wolanski did knowingly restrain the child in this matter after she picked up the child and took him into the attic. Being as she took him upstairs, the attic door was shut, and the child, by I also believe by testimony from Officers Candell and Turbo, is an autistic child, and so that the by being taken into the attic, the child's the child was forcibly the child's movements were interfered with and his liberty was restrained by Ms. Wolanski, who did not have lawful authority to restrain the child. Secondly, I believe the people have proved with probable cause evidence that Ms. Wolanski did secretly confine the individual, as the attic door was shut when police arrived at the location, and the only exterior way to see into the attic was covered by a blanket, and that Ms. Wolanski failed to call 911 and also failed to take any meaningful steps in order to, as she was claiming, to return the child. In People v. Cossack, it was quoted that I believe it's the Michigan Supreme Court stated that secret confinement means the deprivation of assistance of others by virtue of the victim's inability to communicate his predicament. Here, again, by testimony from Officers Kendall and Turbo, the child was autistic and the child had no way to contact the outside world at this time, Your Honor. And so with that, the people would ask that this be bound over to the circuit court as charged in the complaint, Your Honor.
Mr. Abbott.
Thank you, Your Honor. The evidence is that Ms. Wolanski, testimony we've heard, the story she told, is that she found this child in the street in the middle of the night. The child's autistic and could not communicate his name or his address or where he lived or any. He was cold, that she took him home, and that she took him upstairs and she fell asleep upstairs on a mat that's up there. I think there's a couple of elements missing in the proofs today. The first is restraint, and if you look at the statute and you look at the jury instructions, it requires, it's different than kidnapping where it's only knowingly restrained. In this unlawful imprisonment, it requires forcibly constrained or forcibly confined, and forcibly is discussed in People v. Jarrell 356070, is a Court of Appeals case from 12/1/22. That it's, any use of power or violence or pressure exerted on a person to restrain their movements or to confine that movement. So it includes both physical force or a credible threat of harm. And here, there's been no evidence, and there's been no testimony from which you can infer that there was ever any forcible confinement or forcible restraining of the child. Aside from perhaps escorting him out of the middle of the road when she first encountered him, I don't think that could be identified as restraining. If you find a child in the road as an adult, as a member of the community, it's your duty, I think, to remove the child from risk of harm. You're not restraining his liberty, you're guaranteeing that he's going to live long enough to have liberty. So I don't think there's any evidence of any forcible restraint or restriction of movements. And certainly, if the story that was told about how Camden Johnson, the child Camden Johnson, became at large, he walked out of his own house. He opened his own doors to his own house and walked away from there. So if the court will recall, and I can play our exhibit 1 again if you'd like me to, but if you recall that exhibit, that video, as the officer Candle arrived at the house, the front door was not locked. He just knocked on it and it's opened up. He went in the porch, and then the main door to the house was not locked. And he spoke with the man on the bed, Mr. Kidd, and told him where they eventually found the door to the attic. And that door was not locked. And then when he called up the stairs, Camden, walked to the top of the stairs and then walked himself right down the stairs. And granted, there are steep attic stairs, but there was no barrier to Camden climbing down those stairs or opening that door. He could have walked out of that house anytime he wanted to. There was no evidence that he had been restrained. In fact, he was running around up in the attic. Or maybe he was, whatever he was doing.
I don't have any evidence of what he was doing in the attic.
Well, we don't know what he was doing in the attic. My client was asleep, and when the officers showed up, he was there and came downstairs. But there's no evidence that he was forcibly detained or forcibly restricted or confined by force at any point. The other element is under 3B, the person was secretly confined, 3B of the jury instructions, which is also part of the statute. And there's a case, People v. Morris, which is 351-875. It's also a Court of Appeals case from August of 2021. States that the secret confinement as contemplated by the statute is deprivation of the assistance of others, as counsel has identified. Secret confinement is not predicated solely on the existence or non-existence of a single factor, rather the consideration of the totality of the circumstances is required in determining whether the confinement itself or the location was a secret. And in this case, Your Honor, we've heard testimony that as Ms. Wolanski walked in the house, Mr. Kidd, and she had some conversation, Mr. Kidd was aware that the child was in the house, so she wasn't keeping it a secret from Mr. Kidd. And in fact, when Mr. Kidd, at some point that morning, is the person that phoned the police and said, the child is here, he's up in our attic. And they came and found the child in the attic where Mr. Kidd. So certainly his location was not a secret for Mr. Kidd, and Mr. Kidd was not intending to keep it a secret and called the police as soon as, I'm not sure what motive, but anyway, it was like 7:30 in the morning when he made the call. So the child had been missing for 3 hours or 4 hours. It had been at the house where the defendant lives for an hour or so. At any rate, there was no secrecy there. And the fact that Ms. Wolanski contacted her sister, she's not keeping it a secret. The fact that she was Googling what to do when you find a child is further evidence that she had no intention of keeping it a secret. So there's been and there's also been no testimony about how long that blanket's been over that window in the attic, or whether anybody anywhere could see in that window from any place anyway. So I don't understand why that's a big deal. So there's no confinement and there's no keeping it secret. The child could have wandered out of that house just like he did wander out of his own home. I think they're missing these key elements of unlawful imprisonment, and I ask the court to not find the case on it. Thank you.
Today was the date and the time that was set to continue and complete a preliminary examination. The burden is on the prosecution. They need to establish probable cause that a crime was committed and then probable cause to charge you, Ms. Wolanski, with the crime alleged. And so probable cause is not a burden to be compared with the burden that they would need to prove that this matter goes to trial. At trial, they need to prove each element beyond a reasonable doubt, much larger burden than what they need to do today. Today, they only need to establish more than mere suspicion that a crime was committed. And that's a flexible common sense standard. And that's based on the circumstances and facts presented today at the hearing. I had testimony on the 3rd of November from Officer Kendall, who testified that he reported first to an address of 3130 Turner and reported a missing child, and then 2733 several hours later, Community Street, located in the city of Lansing, Ingham County, state of Michigan, which makes venue in this court appropriate. And that, again, there was several hours, according to Officer Kendall, that took that a search had ensued after reporting to 3130 Turner Street and search for a 5-year-old autistic child who Officer Kendall believes was to be nonverbal. Officer then reported to 733 Community Street based on a dispatch, at which point there was a female in the house and a child, and an elderly man, he said, directed him or other officers to locate an attic where he observed a child at the top of the stairs. The court did see video of the body cam as testimony, as evidence that supported the officers entering and looking, trying to search for entry to the attic. The court could see from the video and from the people's exhibit the condition of the property. So testimony, although objected to, was really not necessary because I could see the conditions of the property. The court also took testimony from an officer, William Turbo, who also reported to go 3130 Turner and then to 733 Community. And he walked in and noticed or saw Officer Candle talking with a child in custody. He also observed a female sleeping on the ground. He stated that he located 2 loaded firearms, multiple crack pipes on the ground. And that when having discussion with the person he identified in court as the defendant, Teresa Wolanski, that she got agitated, picked up a crack pipe and threw it. Then we heard today a testimony from Officer Bailey Uberoff, who was able to identify the defendant today. He stated that he reported 733 Community Street after being dispatched by officers. There was a call after 3.5 hours of searching that indicated to the officers where the child could be located. Officer Uberoff testified he did Mirandize the defendant. She waived her rights and told the officer that she was driving in the early morning hours to Quality Dairy when she saw a small child in the street, slammed on her brakes. The child was cold to touch. She put the child in her vehicle, brought him inside and up to the attic and took the child in the attic because it was the only space that she believed to be available. That she tried to Google and or call her sister as to what to do when she located a child, and the child was screaming for their mother. She gave the child her phone. The prosecution is arguing that there is sufficient probable cause as to unlawful imprisonment, which requires at the time of trial that they prove beyond a reasonable doubt first that the defendant knowingly restrained another person. Restrain means to forcibly restrict a person's movement or to forcibly confine the person as to interfere with that person's liberty without the person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, that the defendant did so under one or more of the following circumstances. In this particular case, the restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret. The defense is arguing that the prosecution has failed to provide evidence to support some of the elements here. One of those arguments is that there was no testimony or no evidence that support forcibly confining. The testimony that we have by way of Officer Uberoff is that the defendant was driving and saw the small child, felt the child was cold, that the defendant put the child inside the car, took the child to the house and took the child upstairs. I don't know how much force would be necessary to do that, but this is a small autistic child is what the court knows. I don't know how the child got outside of the house. There's no evidence to tell me or support that the child opened their own door and walked outside. I can't speak to that. But I do know that the testimony is that the defendant was the one who placed or told the officer that she put the child in the car and that she took the child up to the attic. And so the court can infer that some force had to be used to do that. And how much force is necessary for unlawful imprisonment? It doesn't say that there needs to be a certain or particular amount of force. It just needs to be some force. And her placing a child in her car could be interpreted as they're forcibly moving that child or confining the child. Now, whether or not that was with the intention to secretly confine is the other argument that Mr. Abbott is making. There's testimony that the defendant indicated to the officers that she tried to Google where or what to do with the child if you locate the child, and that she tried to call her sister, and that she did not believe calling the police would, or that she believed calling the police would make things worse. There's also just relying on the information that you provided in your argument, Mr. Abbott, in People v. Morris. And we need to look at the totality of circumstances. We have a child that's found in the middle of the street at wee hours of the night. Child is non-verbal. The child is cold. The child is taken to a house, and then several hours later, after there's a search for this child, someone, not the defendant, calls the police and say that they know where this child can be located. Officers get to this house. It's not readily visible to the eye, I should say, what's going on in this house. I don't know why they're in People's Exhibit 1 is a blanket over the window. It could be because there's no shade. It could be because it was an effort to keep people from outside viewing what was going on inside the house. I can't say what was going on upstairs in the attic with the door being closed, although it was not locked. But I know that this is a child that can't speak, and based on the testimony of the officer Uberoff, that was crying for their mother. And then we have an adult who locates this child. An adult at least knows enough how to call their sister allegedly, or to allegedly Google what to do. And if they allegedly Googled what to do, I'm sure Google would probably tell you what to do. But I don't have any testimony about what Google told the person what to do. And if they decided after they found out what Google said, which I'm sure it says you should notify the law enforcement, whether or not they decided to do that. What I have is that they did nothing because the child was located upstairs in the property in a closed attic with that individual. So that's a question for the jury to determine, and more evidence I'm sure would be needed to prove unlawful imprisonment beyond a reasonable doubt, but that's again for the prosecution to do at their trial. I believe there's sufficient probable cause at this state to bind this matter over to the circuit court. So the bind over will take place on the 29th. That's not a date, Ms. Lewinsky, that you need to appear in court. That's the date the circuit court will get the file from this court, okay? There was also a bond violation that I believe was a matter that was connected to a pending matter. Or she have a new charge pending with assault or something on Mr. Kidd.
It's a domestic violence charge, Your Honor, domestic violence second, I believe. It's in front of Judge Ward. I'm not entirely sure the status of that.
But it stems from this same transaction. Okay, because there's a matter pending, I'm going to dismiss the bond violation. And let that matter resolve in Judge Ward's court. The bond in this matter was set at 20,000 cash surety. That will continue. Any additional matters for the record?
Nothing from the people.
Not at this time.
You're all set. Here are your exhibits. Yes. Co-defendants, is one in custody and one's not, is that what happened? Okay, Morel can be brought up, yes. Yeah.